Hi, this is Joel Persinger. I'm the Gun Guy. Thank you very much for watching my videos. I really deeply appreciate it. Listen, I've done two previous videos on Gunmageddon and how it affected us in California as gun owners. And this is part 3 of that. I broke it into 3 sections because the California Rifle and Pistol Association, along with the National Rifle Association and others, did a series of 3 webinars on this. And what I'm doing essentially is recapping the webinars for you. The third in the series of webinars covers the remainder of the laws that we haven't already talked about. If you want to know about the assault weapons ban or the ammo restrictions, those are in the first 2 that I've done, and you'll find the links for those in the description, so you can go back and check out those videos as well. And I do urge you to also check out the webinars that were done by the CRPA and NRA attorneys. They're outstanding. Listen, I made some notes, and I'm getting to be old, so I got to get my reading glasses. I went through this entire webinar, and I'm kind of stunned at the stuff that California does, even though I've been in California all my life. I remember a time when it wasn't like this, and unfortunately it is now. But let's talk about lending first. There's that one about you can't lend a buddy your gun. That's AB 1511. Now, it's not as bad as I thought it was going to be. There was a whole lot of misinformation sent around about it that was kind of confusing. That doesn't mean it's good, because it's not, but it's not as bad as I thought. In fact, I didn't know there was a current law that covered any of this. Under current California law, up until December 31st of this year, of 2016, that law is still in effect, and then January 1st it changes. But the current law says that you can infrequently lend a firearm to someone whom you personally know for lawful purposes for a period not more than 30 days, provided the recipient has a firearm safety certificate or unexpired handgun safety certificate if the firearm is a handgun. Now, I've lived here all my life, and I'm pushing 60 years old, and I never knew there was such a law. So obviously it's not something anybody has ever enforced. I'd never heard of it before, but that law does exist currently. What AB 1511 did was essentially change that someone whom you personally know section of that and make it more strict by listing who those people could be. Everything else in it is pretty much the same. But what they did is they took it and from a general sense and then listed parent, child, sibling, grandparent, grandchild. That's it. Someone you personally know, you can lend it to them for up to 30 days as long as it's a parent, a child, a sibling, a grandparent, or a grandchild. I guess if it's your cousin, you're stuck. It has to be for lawful purposes, not more than 30 days. If the firearm is a handgun, the handgun must be, and this is something I did add also, if it's a handgun, the handgun has to be registered to the person who's doing the lending. So if I'm lending you my gun, then it has to be registered to me. And that's a sticking point in the state of California, because there's a lot of handguns that are owned by people in California that are not registered because they purchased them a long time ago, or they moved into the state and didn't tell the state they had them. And you're supposed to do that, but as a practical matter, hardly anybody ever does. Or you inherited it, or whatever the case might be. And I think this is sort of a backdoor way of getting you to register guns that they don't know you have, because in order to lend it, it's supposed to be registered to you. Now, also provided the recipient has the certificates, either a firearm safety certificate, which is not easy to say, firearm safety certificate, or unexpired handgun safety certificate. Now, the truth is anybody going to obey this law? No, nobody obeyed the previous one. And half the time, people don't even know these laws exist. And the previous one was not in any way that I'm aware of ever enforced regularly, so I don't suspect this one will be either. But let's go over a couple things. Infrequent. What the state law says infrequent means is 2 things. If it's a handgun, infrequent means that you can only lend it, you have to lend it less than 6 times per calendar year. So only 5 times per calendar year can you lend it to someone, to that person. I assume that's to a person and not in general associated with the gun, but it's kind of vague, so I don't know. For firearms other than handguns, the state says infrequent means occasional and without regularity. Once again, for handguns, infrequent means less than 6 times per calendar year, and for long arms it means occasional and without regularity. I have no idea who's going to define, okay, who gets to figure that out? Is it the judge? Is it the police officer? What does occasional and without regularity mean? That's about as vague as it gets. Now, there are some other exceptions that apply to this, and they are as follows, if they make any sense at all. You can lend the gun to someone while you are personally present. I guess that means, if you're showing it to your buddy or something, or you're going to take it over to the house and let them, or you're going to go out to their property and shoot there. and you're personally there when they're using it. Another one is while hunting, but that only applies to long guns. It does not apply to handguns, so if you're a handgun hunter, I'm not sure what you do there. While you're at a target facility or club, or an organization organized for the purpose of practicing target shooting, then you can lend it to somebody. But I think, again, the part that doesn't make sense to me is you're personally present, if that's the case. And also as props for the entertainment industry, movies, videos. I'm a YouTuber, so you can lend me a gun if you want. It's an exception because it's being used as a prop or in the production of some sort of entertainment, whether it's movies or whatever. And again, we'll put those up on the screen so you can see them. And those are the exceptions. While you're personally present, while you're hunting for long guns only, while you're at the target range, or as props for a movie or something along those lines. So that's AB 1511, the lending law that I know I was concerned about, and I've mentioned many times, and there was a lot of misinformation about. Frankly, after you read it, there's just not a whole lot of there's not a lot of news to it, other than the fact that I don't know how anybody could ever enforce it, or if anybody ever will. It's just a dumb law. Welcome to states like California, including California, where idiotic laws are written and passed, and that was one of them. All right, let's move on to AB 1695. That's the false reporting of stolen or lost firearms. Now, what's interesting about this is there have been a number of bills that have been passed by the California legislature, which has been sent to Jerry Brown, Governor Moonbeam's desk, and he's vetoed them. And essentially, each one of those bills has said, if you lose your gun or it gets stolen, you are required to report it to law enforcement within so many days, and if you don't, you're a criminal. It's a crime. And he's vetoed those. He did not veto this one, but interestingly, this law does not require you to report your firearm lost or stolen. It only makes it a crime if you falsely report your gun lost or stolen. I'm not sure what that means. What happened to that AR-15 you didn't register? Well, my buddies and I were out we were out shooting out in the desert, and I put it on the tailgate of the truck, and we drove down the road, and it must have fallen off, officer, because it's gone. Yeah, okay, or some cockamamie tale like that, which is all good and fine and well until you get caught, and then you violated this particular law. You made a false report to a police officer or filed a false report regarding a firearm for lost or stolen firearms. It makes it a crime to do that. The stupid part about it is it has always been a crime to make false reports to law enforcement. That's a crime in and of itself. However, what this did, and it's a misdemeanor too, this is also a misdemeanor. What this did, which is really, really draconian if you ask me, is they added part of the penalty for being found guilty of this is the violation carries with it a 10-year mandatory restriction from firearms ownership in the state of California, which means if you report a gun lost or stolen and you lie about it, and you're convicted of that, then you lose your firearms rights in the state of California for 10 years, and it's mandatory. Now, you're not from California. You're from some other state where you don't have to worry about this, and you're thinking, I don't care about that. And if it happens to be in California, I'll just move. Well, here's the problem with that. Some states look at these things from other states, and then they won't issue you a permit to carry, or they won't let you carry, or they'll restrict your firearms rights in their state because you are restricted from some conviction in another state. Now, I'll give you an example of that. I was in Utah just the last couple months, and out there renewing my certification as a Utah concealed carry permit holder, or carry permit instructor rather. And during the legal part of it, this question came up, and one of the things the instructor said is, yes, if you're trying to get a permit from Utah and you have a prohibition against firearms ownership or possession in another state, even though it's a state law and it's only valid in that state, and it really isn't legal in Utah, it doesn't matter. They won't issue you a permit because you have that violation in another state. Now, I thought that was kind of odd, but I'm just mentioning it because if you think that the laws of other states don't affect you if you get a conviction in the other state, now you live in a different one, well, guess what? Sometimes they do, so be aware of that. Now, this can change dramatically if Proposition 63, which is the Newsom initiative, he's kind of a knucklehead, so if I mispronounce his name, I don't feel too bad about it. But if Newsom's initiative passes, that's Proposition 63, it will make this worse. Here's what will change. Effective July 1, 2017, because if it passes in November, they have to give some time for people to Figure it out. But if Newsom passes, these restrictions will be added to that. Effective July 1, 2017, it will require you to report a lost or stolen firearm, which are the kind of laws that the governor has previously vetoed, and you have to report it to law enforcement within 5 days of knowing that the gun is gone, or within 5 days of when you, quote unquote, reasonably should have known that your firearm has gone missing. Now, I don't know how anybody determines that. Is it law enforcement that says, well, you should have known, and it's 6 days? I don't know. But that's kind of the way that's written. Also, you are required then to notify law enforcement if you recover the firearm, and you're supposed to do that within 5 days of recovering it. Now, here's the problem with that. You report it stolen, or you report it lost. And then you remember, oh, that's right, I lent it to my buddy a couple of months ago, and you get the gun back, and you report to the law enforcement agency that, yeah, you got the gun back. And they're going, where was it? Well, I'd lent it to a buddy. How long ago? 2 months ago. Oop, that's more than 30 days. You just violated the other law, that's a misdemeanor. Or some idiotic thing like that. Or, you know, I thought the gun was stolen, but it wasn't, and, you know, well, you filed it. You know, this is a way to nab you 6 ways from Sunday if this passes. Now, it does not include antiques. If you have an antique firearm, it doesn't count. And there are some exceptions for law enforcement, of course, for U.S. Federal law enforcement, the National Guard, and so on. This is all if they lose a gun in the performance of their duties and report it to their agency. Then they don't have to report it to the state. Federal firearms licensed dealers, if they lose a gun or it's stolen, they have to report it to the federal government immediately, and so they don't have to report it to the state. And if the firearm was lost or stolen prior to July 1, 2017, you don't have to report it. So what's the moral of that story? What happened to that AR-15 you had? Oh, I lost that in June of 2017. Why come you didn't report it? Well, I wasn't required to, officer. Now, look, I'm not suggesting you do that, so don't tell somebody, well, you know, the gun guy told me I should lose all my guns before July 1, 2017, and just tell him I lost them early. Yeah, don't do that, please, because that's not what I'm suggesting. What I'm pointing out is the fallacy of these idiotic laws, and then you do whatever you want to do. All right, if you violate this thing, the first 2 times are fines, the third time is a misdemeanor, and then, of course, falsely reporting anything is a misdemeanor anyway, and so that's where that goes. And we'll put those violation numbers up there for you so that you can see them. Again, first 2 times a fine, third time subsequent ones are misdemeanors, and of course falsely reporting is a fine, but it can also be a misdemeanor for falsely reporting a police report, and that's been the case for a long, long time. Okay, so let's get to the one that most people are really itching about and complaining about and whining about, including me, just in case you're wondering, and that is SB 1446, and that's the one that restricts, quote unquote, large capacity magazines. Now, for those of us with any sense, we realize that those are just normal capacity magazines, and the ones that are required to carry less are what we might call neutered magazines, okay? So if you have normal mags, the state of California considers them to be large capacity, and that's the way they term them in the law, and that's a magazine that carries or has the capability of carrying more than 10 rounds. So in California, you're limited to 10 rounds or less if it's a semi-automatic firearm, and there you are. All right, effective July 1, 2017, this is the law as it was passed and signed by Jerry Brown. Now, so that you know, all of these things are law as of January 1, 2017, but many of them don't become effective or do anything until later in the year. And that's so that people can adjust to the fact that the law has changed. At least they're nice enough to give us a little time. In this case, and I don't know why that is, they're never nice about anything else, but they're nice about that, so I'm grateful. Effective July 1, 2017, this ban goes into effect, and it's a ban against possession. It's not there's already an existing set of laws in the state of California that make it a felony, potentially, to import from another state, to buy, sell, transfer, give away, whatever, or manufacture a quote-unquote large capacity magazine in the state of California. If you're doing any of those things are already illegal, and that can be a misdemeanor or a felony. It's my understanding it's a wobbler, depending on the circumstances. So that law doesn't change. If you go to Arizona or Nevada and you buy a bunch of mags, you bring them into the state, that's already a crime. If you bought a bunch of parts at the gun show and you go home and put it together, that's manufacturing, that's a crime. If your buddy has a bunch of them that he had a long time ago and he gives them to you, sells them to you, whatever, that's transferring. That's a crime. Those are all crimes in the state of California already. But what we don't have a crime is possession of it. It's all in California. It's all how did you get it? There's not a possession ban, but there will be as of January, and it goes into effect July 1st, where it is the mere possession of the magazine that is the crime, in addition to all those other things. And there is no grandfathering. In California, if you had a magazine prior to the ban that's in effect right now in 2016, that magazine is still legal for you to use and possess and do what you want with it. You can even leave the state with it and bring it back. It's all kinds of things. Well, as of January 1, that law changes, and as of July 1, 2017, the mere possession of a magazine, I don't care when you got it, how you got it, or where you got it. If you got it many years ago, there is no grandfathering. All those grandfathered mags become illegal. It requires reporting of lost or stolen. I'm sorry, I might look at the wrong thing. My apologies. Let's see. It's punishable by fines regardless of the date the magazine was acquired. So there is no grandfathering. It requires any person to dispose of any large magazine prior to January 1, 2017. It does not include the following, and this is kind of interesting to me. It does not include magazines that have been permanently altered to accept no more than 10 rounds. So let's say you got a P-mag or you got some sort of a mag that will hold 30 rounds for your AR. If you pin it or rivet it so that it will only hold 10 mags, that's fine. But you got to do it in such a way that it would be permanent, so that it would require some work to restore it to what it was, and you might end up destroying the mag in the process. Now, I'm not sure what permanent means, and nobody knows. I'm just sharing with you what the lawyers on the webinar said, so that you get a clue for that. It can't just be something that's really temporary. It's got to be permanent. All right, it doesn't include 22 caliber tube magazines of the type that would be on like a Marlin Model 60, which is a tube-fed gun, and they can hold 14, 18 rounds, doesn't matter. Those are not interchangeable magazines, so they're not counted here. Also, tube magazines or tubular type magazines that are on a lever action firearm are not banned, so those don't fall into the ban either. Now, a violation is an infraction. It's like a traffic ticket, and the fines are $100, $250, or $500, depending upon whether it's your first, second, or subsequent violation. So if you got 27 mags, you get stopped with them. The first one is $100, the second one is $250, and the rest of them are all $500 a piece. The question was asked of the attorneys, if you got stopped with 27 mags, is that one violation or is that 27? And the attorneys all said they think the state of California would try to convict you on 27 separate counts rather than on just one. So be aware of that. You might be able to bargain it, plea bargain it, or whatever, but there you are. Now, the above is a possession ban. I want to remind you again, it does not take away the other things which are potentially felonies, which are, importing a magazine into the state, transferring it to somebody, whether it's bought, sold, traded, given away, doesn't matter, or manufacturing it in the state by getting the parts and putting it together. All those things are already illegal, and it's a wobbler. It can be either a misdemeanor or a felony. Now, here's the exceptions, and I'll put them up on the screen for you. If you owned a gun prior to January 1, 2000, for which there are no magazines that hold 10 or fewer rounds available, then you can possess that large capacity magazine, but you can only use it with that firearm. So even if it fits something else, you can't do it. You can only use it with that gun. Law enforcement agencies are exempt, that figures. Sworn police officers and sworn federal law enforcement officers are also exempt. They can buy them, get them, whatever they want to do. Certain, they can't sell them to a non-LEO or something like that, but they can buy them and acquire them. Certain retired sworn law enforcement, both federal and state, are exempt for possession only, which means they can possess the ones they had before they retired, but they can't go get any new ones. And then most of the other exceptions, whatever they are, that are currently in California law also exist. However, there is no longer an exception for taking a large capacity magazine out of the state and then bringing it back into the state. So if you're retired law enforcement and you've got all these mags and you decide to go take a class at Gun Sight, Front Sight, or something else, and you take them with you, and then you bring them back in the state and you get stopped, well, that's importing. That's potentially a felony. And each one of those magazines is going to be treated potentially as a separate felony count or separate misdemeanor count, depending on how it rolls. So that, I think, is absurd. Once you own it, you own it. But now they've changed that, so now that doesn't apply anymore either. All right, how do you comply with the law? If you're going to comply with the law, now, a lot of people saying, we will not comply. I get it. But if you decide you're going to comply with the law, this is what you got to do. These are your choices. 1, remove the magazine from the state. 2, Sell the magazine to a licensed firearms dealer. I don't know why anybody would buy it because they can't do anything with it either. 3, destroy the magazine. Please don't. Remove it from the state or some other option, I hope. 4, surrender the magazine to law enforcement for destruction. I really have trouble with that. That to me is the state confiscating personal property that belongs to people and was legal when they purchased it, and I see that as wholly and completely wrong. But then, forgive me, I see all of this as wholly and completely wrong. The Second Amendment is very clear when it says the right of the people to keep and bear arms shall not be infringed, and these are all infringements. Nevertheless, your 5th choice is to permanently alter the magazine so that it does not hold more than 10 rounds, because if it doesn't hold more than 10 rounds, it's not a high-capacity magazine by California standards. As long as it's permanently modified, then it doesn't hold 10 rounds, and it's not a high-cap mag. I don't care what it says on the side. If it says 30 or whatever, you put how many rounds can you stuff in it? 10. Okay, you're done. There is no grandfathering. I want to remind you about that. No grandfathering, period. So if you have old mags, guess what? They don't count anymore. You still can't use them beyond this year because it's illegal. Now, it's not going to start affecting people until July, but the law actually is the law as of January. All right, if Newsom passes, that's the Newsom Initiative, Proposition 63, please vote against that. Vote no on 63. Please, please, please. It makes all this much worse. If Newsom passes, then possession is illegal still. It's punishable, though, as an infraction. Watch this. $100 per magazine. Now that may seem better to you than the tiered fees, or $100 per magazine as an infraction, or as a misdemeanor, $100 per magazine, and or 1 year in the pokey, 1 year in jail. So now they're saying, well, you know, look, if you've got one of these mags, you just own it. We can fine you $100, or we can fine you $100 and we can throw your fanny in jail for a year. This is for property that people purchased lawfully and have had lawfully for a long time. I have some. I got to take them out of the state or modify them. I have them because I bought them back in 1990 and 1989. And they're perfectly legal for me to possess in California right now. But by July 1st, I got to do something with them if I'm going to comply with the law. And so there you are. And you know, I've said this before. People say, I'm not going to comply, I'm going to do what I want, and they're going to have to fine me, and I get it. I'm not suggesting that. And the reason I'm not suggesting that is many reasons, not least of which is that I'm a YouTuber, and this show is not in the business of suggesting people break the law. I don't make those suggestions, and I'm also, because of the YouTube thing, I'm kind of a semi-quasi, I guess, kind of public person, and so I can't do that. I can't suggest that you do that. I can tell you what you should do, and you can take issue with me because I'm not saying rah, 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 go break the law. But I'm not saying that, and there's many reasons why. Then you can go do whatever you expect that you think is best for you to do. In any case, that's the breakdown of these laws as I understood it. Again, there's a lot more to these things than what they said on the webinar, and I've kind of highlighted it for you and given you the high points on it. I want to encourage you to watch the webinars yourself. I've got a link in the description for you to do that, and also check out the other videos I did, the other two. And then they're going to do a webinar on the Newsom Initiative, Proposition 63. As soon as that comes out, I'm going to watch the webinar, and then I'll do an update for you on that so you know what we're facing, and they're going to get into more detail. Now, you'll find if you watch the webinars, there is a book that is updated every year that is written by the lawyers that represent NRA and CRPA at Michelle & Associates, and it really has all the detail for these. I will see if I can find a link to that book, and if I can, I'll put that in the description for you as well. Listen, thank you very much for watching my videos. I really deeply appreciate it. Please like, subscribe. That's why we have the button up here for you to do that, and if that button doesn't work for some reason, then you can always find the buttons in the description or the links in the description as well. Also, check us out on Facebook, Twitter, and on the blog. I have not gotten to writing too many articles on the blog lately. I got some catch up to do, but I will be adding a few here in the next coming weeks, and I try to keep them as interesting as possible. So check out the blog as well. Now, if you're not a member of the National Rifle Association and you're concerned about gun rights, you need to be. So I'm going to put a link right here for you to do that. And if that link doesn't work for you on the screen, again, all the links are in the description. It will save you some money, and you can join the NRA for less than the cost of one box of ammunition for a year. And right now, the National Rifle Association is spending a ton of money on lobbyists, lawsuits, and as I said, they have a very prominent and powerful set of attorneys here in California that have represented them in California and across the nation for decades, and they're fighting a lot of battles here. Are we winning a lot? No, but what you got to understand is if the NRA and CRPA and Gun Voters of California and the Second Amendment Foundation and these organizations weren't fighting all the time, California would be a lot worse than it is today. So I urge you, please join. If you join nothing else or no one else, join the NRA. That's why I've got this link here for you to do that. Also, if you have a gun at home and you think you might have to use it to defend yourself, you're going to need some legal backup too, no matter what state you're in. I use a company called Second Call Defense. I highly recommend them to you. You can check out Second Call Defense and more about them at this link right here or the link that's in the description. Thank you again for watching my channel. I deeply appreciate it. Have a wonderful week, and please be safe.